So Anthony, the first question I want to ask of you is, what drew you to the law, and why did you find yourself in the Northern Territory working for Aboriginal legal aid?
Sure, and so thanks so much for inviting me and all of the Elder Australia team to this conversation, and thanks everyone for coming. Just before I do begin, I too want to pay my respect to the Ngunnawal and Ngambri people and acknowledge that we are here talking about, I suppose, law and pathways in the law, but it's colonial law, and we're talking on country that's known law for time immemorial. And so it's critically important that we keep that in frame, that right beneath our feet is that experience, whether we can tap into it or not. So it's an important conversation, and not to preempt you or why they're two white guys, it's an important conversation for everyone to have, not least those that as males and as white males stand perhaps at the hierarchy of the privilege spectrum and perhaps stand the most to gain from experiences of walking and being on stolen land. That's not exactly where you wanted the question to go, Travis, but that's okay. Yeah. So your question again was, what took me to the Northern Territory to work at the Aboriginal Legal Service?
Yes, what initially drew you to the law, and then what brought you to the Northern Territory?
So to the law, it was really ultimately an idea of looking for something at the end of year 11 and 12 that where I felt like I could make a contribution and could make a contribution to work with people to face injustice, and I was sort of alive in at least an academic and intellectual sense, perhaps as a Canberran might be in a more bookish sense. But law seemed to me to offer the potential to really do good work for people and people in situations of significant vulnerability as a consequence of systemic forces that were bearing upon them. And so that took me to law school, where I studied an arts degree and a law degree, and the two things in the first few years of law school, which is at University of Wollongong, that kind of coincided was criminal law, and really kind of engaging with, in a fascinated way around criminal law, but particularly the stories that often weren't told, but sometimes were there around what drew people into the criminal justice system, what forces brought upon them. And also then studying Indigenous Australians and the law, as it was called at Wollongong, and kind of realising that was kind of a core intersection of colonial injustice, and colonial legal system meeting people and doing just appalling things if we step back from what was going on. So in a sense, it became for me a natural focus for my attention to want to work in criminal law, but to want to work at that stage, I would say probably for Aboriginal and Torres Strait Islander people. I don't think getting the with thing was really was something that I had fully come to terms with.
But it is interesting that you focus in on stories, bringing you, which stories inevitably will bring you to a kind of witness, because they're about investigating the people behind the crime, as it were, or behind the systemic problems that they might live through.
Yeah,
one might live through.
Absolutely, and I think from early days of uni, but before that, I've been fascinated by human stories and by people, and had a desire to try to stay open to those stories. Sometimes I think law school crushes some parts of that motivation that we might describe as a kind of empathic or even, perhaps even a compassionate motivation. We tend to start thinking only about the law as opposed to the human beings and even the planet that the law is meant to serve, you would hope. But yeah, so that, I suppose, intersected, and that led to an internship at the end of third year. And that internship was, I read a book about the Aboriginal, Central Australian Aboriginal Legal Aid Service, as it was then called, and it's called Lawyers in the Alice, and it was all white lawyers, I think almost all white men. But I came at it and it still struck me powerfully, and I was studying about self-determination and the Aboriginal legal services and the boards, and I got fascinated, and so that drew me to an internship in Central Australia, and that kind of blew my mind. And so, I was only there for 3 weeks, but within the space of a week, I met my current partner, who's Aboriginal field officer there. And when I say my life partner, let's call her that, who, let's make no bones about it, is represented in part by the character in the book, Geordie. But she was a field officer there, essentially assigned, much to a horror to begin with, but ultimately it was okay, to look after me as the next white person on the conveyor of kind of interns and lawyers that would come up, with the job to be, be that go-between, be that bridge, be that person who could actually assist me and the other lawyers to do some good. Perhaps didn't really have a full grip on any of that. But within 3 weeks, it had become something that I knew was just part of life and something I'd return to. So one of those experiences that turned things and cemented. But it was also, so it was definitely, it was the Indigenous staff, the Aboriginal staff out there that were perhaps had the most striking impact. But there were a lot of non-Indigenous lawyers, often battling their own demons, plenty of alcoholism, plenty of challenges, trying to face that sausage machine of criminal justice every day. However, their values did really accord. Their ultimate purposes, lined up in ways that I hadn't experienced perhaps in a lot of other legal settings. And so it was, it felt like a messy home, but kind of the start of something that could be a bit of fun.
Well, and then that sort of bridges well onto my next question for you, which is how did you come to write Belonging being relevant to home, I guess. So why did this book emerge? Why did you feel the need?
So the book emerged, so I went out as an intern, then went overseas with my partner Kelly, and then came back and worked at the Aboriginal Legal Service as a paralegal for 6 months, so more experience on the ground at that stage. Went off to finish a law degree now in Queensland, and then returned to work and began working as a lawyer at the anti-legal aid in the Aboriginal Legal Service. And I was only really there, I was there for 4 years on that last stint, and a little over 4 years. But there's a lot that goes on in 4 years in Central Australia, in any criminal justice system where you're working. Don't always like the sausage machine metaphor, but essentially there is so much happening. And you as a young person have come with all of your own experience, your own challenges, often your own emotional, difficulties arising, and you intersect with all of that. And it's an intense experience. It's both incredible, enlivening, and extraordinary. It's also quite depressing and challenging. And you face that reality, and we may come to it, that in a sense, on one level, you're just another cog in the machine of the grinding colonial criminal justice system. And on another level, the people that you represent matter, and each moment in those cells below the court, it matters. And so there's a lot of, there's so much life that flows into you in that space. And in a sense, what happened was I moved away from from Alice Springs, moved to the beach. We had 2 young kids, and so being a full-time lawyer wasn't realistic. I wasn't going to be able to be the dad that I wanted to be. And so in the process of parenting, my mind didn't stop, and essentially all of these experiences started to just need to come out. And it started as a short story, and it went from there. So
well, fantastic. Thank you for that. I've got another question about belonging, but I think in terms of time, maybe we should push on and answer the question as to why we're here tonight, why you accepted the invitation to be here and talk to us, and particularly accepted the invitation to speak with me, or not particularly me, but I mean me insofar as I'm a young white law student interested in this space, and to just kind of help us position the rest of the talk tonight as to why we're here.
Well, I think I'll try to keep my answers short. It's probably going to be a problem. It's going to blow too wide if I'm not careful. But I mean, basically the reason is because of all of not everyone's a student in this room. However, most of you are. And what's extraordinary about law school, and this law school, but say the Law Reform and Social Justice program and students who come through, is that generally speaking, you're all motivated by the desire to do some good work with your law degree. That's core to it. Sometimes we try to beat it out of you, but basically that's there, and that's what drew you. And countless of our students head off and they see Indigenous injustice as the foundational issue for this country. It's built on stolen land. And that unfinished business is something that students are drawn to because it's true. It's truth-telling. It's about a real deep engagement about doing something fundamental for this beautiful continent and the people who belong to it. And then I'm speaking of First Nations people on this continent. And so the invitation to come and speak is about saying, look, these pathways, this is important. This is the work that everyone who stands on this country, who sits and works in this country, has to do. Whether we like it or not, if we do nothing, we're actually doing the work of the system anyway. We're just allowing it to go. So we don't ultimately have a choice. If we unpack our privilege and we're honest about it, it exists on the back of stolen land. And it exists on the back of those histories of dispossession and so on. So I suppose I've probably lost track of your question fully here, but the motivation comes out of saying, well, look, hey, you want to speak about this? This is a conversation of non-Indigenous people, and great respect to any First Nations people in this room, but often First Nations people will say, well, you deal with it. It's your system. You're the one imposing it on us. You need to do the work of changing this. Don't just put it back on us all the time. It's our responsibility, and when I say our Indigenous people, to face that. And I think that I see students doing that, finding their own way. There are countless students who've gone on to the Northern Territory, to what's now called Naja, the work at the Aboriginal Legal Service here. They go to WA and look in the Kimberley for the Kimberley Community Legal Service. They're doing good work. It's conflicted because you're always in a system trying to potentially propping up a system, and yet you're responding to people. And that's back to the story and to the people.
Yeah, there are quite a few questions that point to that very issue. But now I think, thank you so very much, and I think a lot of people will be saying here to those beautifully articulated comments. I think now we can move on to a more in-depth discussion about the book itself, Belonging. And before we do this, we did spring this on Anthony beforehand, so I'm just beforehand, so I am sorry about this, but I will ask you to read a passage from the book. For all those,
bear with me, it's a longish passage, but I'm directed to do this.
It is a longish passage. He's being directed. It's okay. It's like a page and a half, and you can read along, I guess. But no, just experience the melodious sounds of Anthony's voice. And yes, I think you know where it goes.
I'm onto it.
Wonderful. So over to you, Anthony.
Ben had come to Alice Springs to work for Aboriginal people, hoping that their cause might be his higher purpose. But on reflection, he wondered whether he'd subconsciously been drawn to Central Australia by the promise of what he might learn from peoples whose ancient links to family and land gave them certainty of place. He'd now come to realise how idealised his vision of Aboriginal Australia had been, how the burdens of colonisation could undermine a people's spirit, resulting at the extremity in the tragedy of suicide. But what considerable strength remained in the people of the Central Deserts was still drawn from the land, ancestry and family. For all of that, 6 months after his arrival in Alice, he found himself in Tennant Creek, yet another exploratory foray. From euphoric beginnings in Alice Springs, feeling like he'd found a place to fight the good fight for Aboriginal Australia, the reality of his position had slowly presented itself. Rushed interactions with clients, followed by hasty court appearances, night preparation for hearings, followed by cases in which often Ben's job was to undermine the credibility of Aboriginal complainants and witnesses who alleged violence was perpetrated by his Aboriginal client. It made a mockery of his crusade. At the end of a case, its waters muddied by language barriers, limited interpreting and cultural misunderstandings, Ben was never sure where the truth lay. Some of the lawyers celebrated their forensic victories over a beer at a local bar, but the exercise left Ben feeling hollow. He was conscious of the emptiness of celebrating the victory of one Aboriginal person's story over another. It was different when you could sink your teeth into a case involving police misconduct or brutality, when you could experience the feeling of battling on behalf of your client against the institutionalised racism of the state juggernaut. But while such cases did arise with some frequency, a frequency that had been reduced in no small part due to the efforts of lawyers holding the police to account, the recurrence was much rarer than the day in, day out drink driving and domestic violence. Indeed, it seemed to Ben that some of the best police, particularly on the communities, achieved a good deal more for people by stemming the tide of alcohol and violence than he could hope to do as a lawyer. Ultimately, his move to Tennant Creek was prompted by the realisation that he and his fellow lawyers did not have the answers. It was both sobering and liberating to realise that he, a well-intentioned white middle-class outsider, had fallen into the trap of paternalism, like so many who came before him. Ben had come to Alice to reach out to those he saw as less fortunate than himself, when the those didn't see themselves in that light. Tennant Creek, Ben hoped, would be a chance to loosen the grip of his preconceptions and learn how the people here saw themselves and their situation. Maybe then he really could be useful.
Thank you very much. We asked you to read that passage because I think it really does set the stage for a lot of the questions that are going to come. But the first section, as I got here, there's a lot to unpack in that section. But one question that I certainly want to ask is, what is this trap of paternalism that you speak of in the passage? And how can we navigate a process of learning and unlearning when being immersed in the criminal justice system?
Right. So
Easy ones first.
So, I mean, I think at core, paternalism is a denial of the equality of human beings and inherent dignity of others. But it's something that we are trained to do through always comparing and looking either up or down at people and thinking of things in these sort of comparative rather than interconnected terms. And so we can stray into paternalism if we're honest about what's happening in our minds when we see a situation. We can often find, or a person's experience, that we have strayed into this kind of comparative thinking that places us in a position of hierarchy. And I think that this is commonly the experience that you find, and people are more or less kind of alive to these emergencies because they're natural processes of emerging. It's a bit like unconscious bias. These things are there, you don't notice, and then you start to learn, you capture yourself a few times, and the unlearning can't happen until you start unpacking and being honest about that fact.
So is that then perhaps encapsulated in an interview you did for the ANU Law School? And in that passage, you talk about a distinction emerges between working for and working with. And is the working for then the paternalistic stream, whereas the working with, I don't know, the good stream. I don't know what adjective to use, but is that encapsulated in that distinction?
Yeah, I suppose you could say that. I mean, words and English words are hard to capture what is really quite a deep and potentially embodied experience of interacting and how we interact as human beings across very different life experiences. And so I suppose the idea of the language of with, or what it speaks to me of, is this sense that there is, despite difference, despite all of these challenges, the capacity to interact in the moment that doesn't have hierarchies, that engages with whatever may arise in that space. Now, that's probably not quite where you're going. What it's meant to capture, I suppose, the for is, well, I'm here to serve, and I'm here to serve because you're in such a disadvantaged position, and I want you ultimately, look how advantaged I am, and if I do this work, you will be more like me, and therefore everything will be great. Now, that is just assimilationist, typical kind of colonial thinking in its face, and it denies straight away the strengths inherent in a person, any person, because you're not seeing the whole person, because you come with an assumption or preconception. So the witness, I suppose, if I'm having to try to put something concrete to it, and I don't think there's anything concrete to it in this moment, it's a little bit like saying, I'll come to this interaction and I know I've got baggage, all right, and I'll try to be alive to it, but I will try to interact in this moment as best I can to see the whole of you. Whether you see the whole of me or not is different, but that's the kind of interaction ideally. Now, is that what goes on in the cells below court? that's probably going a little bit too far. But I do think one of the aspects of the with is you have to be able to see the strengths of the person, of the people. And actually, ultimately, the real transition comes here when we stop thinking, well, it's non-Indigenous people who can help, and there's this element of pity and so on, this denial of equality. And actually, you might find it's non-Indigenous people who need the help, because in a lot of ways we may be materially privileged, or we may be destroying the environment, we may be destroying one another in relationships. But if we could see how destructive and damaging that was, and that there are alternative ways that are based in a different form of wisdom, then I think you realise the strength and power that might be available if we have a different level of really partnering in the justice space or any space.
So, in terms of being young lawyers interested in, or any lawyer interested in this space, then is that an encouragement? I mean, this is also, I'm trying to get more concrete. I want us to get some more concrete language, but it's encouraging an openness. And then what seems to be very important about what you're saying and throughout the book is a process of self-reflection, that one's connection to injustice must be or should be or striven to be embodied, rather than, there seems to be something coming out of what you're saying of we forget the person in the issue.
Yeah, I think that's, I'll try and be more concrete about it, but I think that captures it well. But I suppose the point is we come with an assumption about what justice might look like for the person that we're seeking to do justice for. Now, the point is, what is their conception of justice in that moment? And how can we do justice unless we challenge that and say, well, what is your conception of justice? What is your conception of your life? And if we start with a hierarchy and a kind of denial of equality from the beginning and a kind of pity, even in the face of what can be, incredibly disturbing reality, let's just take the cells, the cold cells in the bottom of Alice Springs, courthouse. If we don't challenge those assumptions we come to, then we don't start to have that capacity to work with, because we haven't really understood the story or tried to even understand. Let's leave it as try to. And then we then aren't even open to the bigger story of the people, which will have its often gross and tragic challenges, really, but incredible strength and power as well if we're open to it. Even in some of the most challenging circumstances.
Such as these?
Yeah.
The black switch near the back door. It's the top one.
Act two. Thank you. I hope you all enjoyed the interval. And I guess we might use that as a bridge to.
So let me just have one crack at making it concrete,
yes.
Right? Yeah. Because and we're sort of okay, how do I as a non-Indigenous person work in Indigenous justice? Well, for a start, the start point is you're working in that space if you do nothing. You are actually contributing to the issue. So you kind of don't have a choice, which means you need to, if you decide, no, I want to be on a positive side of that, you're going to engage. So the next question is, well, how do I start to open up? How do I start to engage? I'm not just going to go and find the First Nations person and say, tell me what to do, I'm a good white person, make me feel okay about myself, away we go, let's do this. But that's different to saying, right, well, I've gone on an internship, okay, I'm out here, I'm open to it, I'm not going to be, pushy, I'm there, and there's an Aboriginal field officer here, and then there's a white lawyer over here. And quickly there's a dynamic of who has authority. One's coming out of a different authority structure completely, one that has a base in time immemorial. One is coming out of what really has the power in our colonial context, which is I know all the rules of this courtroom. And our tendency, if we're not careful, is to go, oh, they're like me, I need to learn from them. That's the real, no, what you're talking about, and this may be subtle, I may be caricaturing it, but the point is, if you seize that moment to stay open, not with your own assumptions, but stay open to learning, that's where you start move along the path of being able to work. Now, whether you get there or whether you don't, whether you sometimes get there and you don't, you fall down, you need to be slapped by another First Nation person who says, you've forgotten everything that we've told you that last time, that's part of the process.
Because I think there can be an anxiety I've certainly felt this anxiety, so well, maybe there's not an anxiety, but I've certainly felt this anxiety that there can be a sense of, I'm going to talk about Indigenous issues, whatever that might mean, and one feels that, no, I shouldn't really speak, that I shouldn't give an opinion or really discuss the issue in a, of course, a, respectful, open light, but there can be a sense of, and that can lead to a sense of resignation of, and resting on your sort of good-natured laurels, rather than actually engaging and risking being cut down, risking being, or not necessarily cut down, but told that you're very wrong. And for many law students especially, I think that's a really awful thing, to be told that you're wrong about something and to be really open about being wrong. But that's a great difficulty. I wonder if you could speak on that. The anxiety that can come with actually delving into the space and the risks that might be involved in actually opening yourself up to vulnerabilities of being accused, perhaps quite rightly, of paternal, colonial kind of that we're really scared of accepting for ourselves. So talk about the difficulties of that.
The first thing to say is those difficulties are just real. There's no way around that. But again, I don't want to sort of hark back to the same point. To do nothing or not engage is actually to do is a position to take in that space. So and it's important to reflect that First Nations people can't walk away from the injustice. So why on this country that's stolen should non-Indigenous people be able to walk away from that? So if you sort of start from the point that, well, I can't walk away, that's not a viable position, moral position, ethical position. Then you're stuck with, right, I'm going to do my best and I'm going to make mistakes. But this is the reflective piece. It doesn't mean I'm just going to go into this and go for it. You need to be aware that you will get it wrong, but to be open to getting wrong and correcting course. And some of the most powerful moments are when you get it wrong, when somebody tells you, this is what you've done, that's a problem, and you feel a sense of shame and so forth. But then you realise, well, they had the courage, in the case of the First Nations person, and respect to tell me that I got it wrong, and that's a real privilege, to be honest. And then you get a course correct chance. But so I think the other thing that we need to all come back to thinking about is that we are, like it or not, part of this system. So that also means that our thoughts are the thoughts of this system. We think the thoughts of the culture. It's an offset, thing, but it's true. And we often, in our individualised kind of context, want to own these thoughts as if they are us, and therefore we're deeply ashamed if we've got this thought that's arisen. But the reality is these thoughts have come to us through our own enculturation, through what's happened in our experience, and it's a colonial enculturation. So we couldn't expect not to have colonial thoughts. The question is, can we start to engage in ways? But denying that, or suggesting to you that there is an easy path here, a way to work in partnerships, it's not real. It's not a reality. But that's no reason not to. And I mean, we may not get to this, but the greatest joys, in my working career have been working with First Nations people. And both in terms of the professionals that I've worked with, but also with the clients. And it's always spread beyond there as well. So that sense of connection that comes, and I'm lucky enough to have a wife who's First Nation, so a huge family that's from the Central Desert. So, I admit there's been a lot of luck in that. But the sense of strength that comes out of just feeling tentatively a potential connection that comes with that is pretty powerful.
So you seem to be, from that, can I kind of briefly surmise that we, as people interested in this area, we need to be sort of cultivating our courage, our openness, our vulnerability, and our self-reflection. From that, there are kind of four things that come out of that are the four kind of values that we need to constantly remind ourselves.
that seems like a nice summary.
Wonderful.
There may be more, but that's a beautiful way.
Fantastic. Well, thank you for those comments. And I will move on to another question now that also comes from the book. And I'll briefly read just two small passages, but the book really paints an awful picture of prisons in the Northern Territory. They're cold and desolate places.
Or extremely hot.
Or I'm sorry, I meant cold in metaphorical sense of, awful step. Oh, and yes, you're quite right. It's quite hot in the Northern Territory. But look, these are the two passages, and I just want a quick response from you from these two. If it can be just let's look, here it is. And it also relates to the presumption of innocence and how that actually works in practice. So the first passage is, Matthew Tate was here in the remand block next to maximum security. It was ironic that some of the harshest conditions in the prison were found on remand, the place you stayed whilst you were presumed innocent. Second passage, let me get this. Even though a court might ultimately find him not guilty because of his mental impairment, the punishment he would receive in the meantime, the months in jail, would far exceed what he could expect if he just put his hand up and pleaded guilty to stealing the truck. So if you could respond to this idea of presumption of innocence and how that actually practically functions in these situations where you've got people that are going to be in remand, but in prison, isolated for longer than they would if they just said that they were guilty.
So, I mean, the interesting passages you've chosen, and I didn't put you up to it, but I think that speaks of the challenge of also working in this criminal justice system, where also as a lawyer, you're trying to work with someone to try and negotiate what is an impossible situation where, for example, somebody might be innocent of a charge, but because they can't get bail, and they may not be able to get bail, let's just take Central Australia, because they've failed to turn up to court in the past. They've gone to sorry business, or they don't have any respect for the colonial court. And, the court wouldn't like to hear that, but let's face the reality. Why, it's a reasonable position to take. Other things are more important. So therefore they build up a non-appearance record. That means next time they're arrested, they won't get bail. And so if you're on, and then it may be a situation where the person is not guilty, but to get to a trial, particularly if it's complicated, to get mental health assessments, for example, which can be very difficult at the best of times, even on the East Coast, but in Central Australia, getting experts in, it might see you on remand for 3 months, even though the offence you might be charged with, if you pleaded guilty, might see you with, let's say, a suspended sentence of imprisonment and therefore walking out the door, so to speak. And so that speaks of a system that really ultimately compounds injustice over time. But it also speaks of a system in which lawyers find themselves in impossible situations ethically, where the practical, and I mean, when I say impossible situations, lawyers are pretty good at working out ways to stick within ethical bounds that are just on the margins.
Well, you refer to them as pleas of convenience, convenient pleas.
Yeah.
And one thing that struck me was in the book, the narrator mentions that they were regarded as ethical. Mm-hmm. But even if on the margins, they were generally regarded as an ethical thing to do would be to help your client, plead guilty so they get out. And that really struck me. I wonder if you could respond to that it is regarded as an ethical position to take.
So the High Court has ruled that if a client says says they're not guilty, but instructs you very clearly that they want to plead guilty, that it's ethical for you to then to accept those instructions and go into court and for the matter to be resolved as a plea of guilty. Now, that has to be balanced with the critical importance of not misleading the court. So it leaves the lawyer very much mute in court, and often a judge or magistrate will pretty much know something's amiss here because there's no story about why something happened. But it's ultimately considered an ethical position. But that's where personal ethics come in with the sort of legal ethical position, and it's deeply uncomfortable to be involved in that situation. And in a situation like the one you described, what's compelling that problem is that really the default position is jail. You know, that's the solution to everything. It's the backstop. And so if you are in jail, unless you put your hand up and plead guilty to something you didn't do, then is that really a choice? And would anyone, if we could put ourselves in that position, not decide to plead guilty in that context, particularly if we have if the system itself is just seen as something that is white justice is going to lock me up anyway, so I'll just take whatever the next route is out and carry on and hope that I'm not in the next day.
Well, especially in this circumstance that you describe in the book, it seems to be compounded by mental illness, and it seems that the result of having this mental illness is that they're on watch, which means that they're completely isolated, which is a really counterintuitive thing to think that, okay, someone's got mental health issues, so we'll stick them in a room alone when they're going to have no contact with anybody. And I don't have a question for that, but I mean,
no, but it speaks to things you must have all seen with Dylan Voller in the Northern Territory. And being placed in spit hoods and all sorts of things, and the treatment of young Indigenous people, women and men, in a system which at least professes to have a rehabilitative aim, as if locking people away in isolation and subjecting them to violence, and state violence, is going to somehow produce people that will exist in connection and within community when they come out. It seems to be a counterintuitive proposition, but it's simply the default position, which is why abolitionist arguments, I think, are starting to get more and more strength as they ask you that basic question of what is this? Why is jail this backstop proposition that we all accept? But yeah, in this particular instant case, and you'll face this if you're a lawyer or a paralegal or anything, and there's at least one lawyer in in the room here today who has probably faced these kind of challenges of what are we going to do practically on my client's instructions. How do we deal with this situation practically and negotiate the best way through this system? And it's a challenge. And once you're a lawyer in that situation, you don't get the choice of turning away and saying, it's a horrible system, I'll step outside it and just criticise it. You're in it, you're there with a person, and they need assistance. So you have to work it out. You've got your legal ethics and you've got your core of humanity, and you'll work your way through that as best you can.
Just looking at the time, I want to get on to some of the more general questions. We might just have one before we start to open it up, so we have a good amount of time to have a discussion with everybody. And a lot of questions that came in the past couple of days were in relation to, I'm just going to read it now. So and you've really touched on this, so, I'll read it out. How can one reconcile working within the criminal justice system, which remains oppressive to First Nations peoples, whilst advocating for decarceration and abolition? And secondary to that is a very strong question. Is it morally permissible to get experience working for the DPP, for instance, in the criminal justice sense, when your job is essentially assisting with the over-incarceration of Indigenous people?
Yeah, so it's challenging questions. And again, I suppose it's not the answer sometimes as having the question and keeping the question in mind that's most important, and maintaining that question in mind. So having said that, I'm now going to let those questions drift out of my mind if I'm not careful, and I won't. But I mean, the first question, really, can you work ethically within the system, and then going more specifically to the DPP? I don't know that we have a choice. I don't know what choice we have. I think one way or the other, we can't really get outside the system. It is on this land. It's colonialism. It's a system. So we can work right in the kind of engine room, okay? Or we can step outside, so-called outside, and perhaps criticise. And in a sense, my career has been both working right in the engine room, and then also being in academia and trying my best to be more of a kind of critic, advocate for justice, change and law reform. But one way or the other, I'm sort of captured by the system, I'm captured by that way of thinking. So I think in that sense, though, that, and if I haven't mischaracterised the question, if you're not in there working, or if you don't open to that possibility as being one way to engage and do good work, then I think you're kind of leaving the floor to people who won't be perhaps motivated and ethical in that way. And also the reality is that there's somebody in the cell who needs help right now. So what are you going to do? It's really a very difficult situation. And if you are the more open practitioner who really is perhaps even just endeavouring to be a person who works with, then you might change someone's life. That life might change and reverberate down the track. You might, for example, represent an Indigenous woman who's a mother who does not spend more time in jail as a consequence, does not lose her children, does not have that cascading effect. And perhaps if you're really lucky, it trusts you enough with that story and that there is a positive outcome. They may not happen enough. It may be pretty difficult work where you get the 1 in 10, 1 in 100 cases where you feel like having impact, but there's a pretty important impact there. And I think that then goes to the DPP. Who do we want in the DPP? Do we want people who are not open to humanity and the challenges and the complications? Or do we want people who can say, well, I'm a representative of the community. I appreciate that this community is the colonial one in the sense of the system that I'm operating in, but at least I'm alive to that. And you, the defendant in this case, or the witness, you're all part of this community and I'll do my best in that space, albeit that I have to ethically apply, the law in these different ways and can't simply bend it to my will. But good ethical prosecutors are really, can make a massive difference. And so, we see that in the court. I've seen that. And so I don't take a view that it's instantly unethical. I do think we're constantly considering that boundary and where we are. And the only other thing, and it's not quite the question, but I just want to say another thing. I don't want you to get the sense that the only way is to work in this system or directly in that engine room, because let's be honest about it, your well-being can suffer enormously in that space because of all these conflicts and what you're doing. And if your well-being suffers and you burn out to the point where you are not able to take care of yourself, and we don't train lawyers generally in law school to look after themselves. We don't talk about self-compassion. We're sort of talking generally about compassion here for others. But if we don't look after ourselves, and I don't mean in a kind of, well, I'll accumulate this wealth and all that, I mean in a kind of really genuine way, then we're kind of no good in that system anyway, no good to ourselves, no good to others. So the reason why I don't think it's necessary to draw that distinction about where do you do the work, I think the work has to be done by everyone. The question is where maybe you could have an impact that works for you and enables you to have a really significant, however small contribution, but even potentially thrive in the process, because it's not doom and gloom. It's actually an incredible privilege to be able to work. And doors that can open to a sense of connection through that process, even through, working in the cells, are extraordinary. So wherever you find that space, wherever it works for you is a way to have that contribution.
So it seems to go back to that, having the courage to engage, but also having the courage to be healthy, I guess. Courage to
absolutely,
yeah.
And to know when that is not, you are going to burn out. I mean, I've had those experiences, not to put too many kind of, fine a point on it. The wellbeing challenges, whether lawyers acknowledge them or not in practice exists for everyone. Some people are more open. It'd be better if more of us were open, but the levels of anxiety and the way people address them, are just incredible. And the common resort is simply alcohol. And why? It slows the brain down at the end of the day when everything's whirring and so forth. But ultimately, in this space in particular, but in all of these real justice spaces where you're talking, think about working in refugee law, think about places where there's real suffering, systemic causes and so on, to survive in that space and to, in fact, potentially thrive, takes a different way of being, and perhaps a way of being that is more connected rather than being kind of individualised.
Look, there's so much more that I want to ask you about art and law, shared meaning versus abstract meaning, dealing with confrontation, being a crusader, on belonging. What is it like being a magistrate? Oh, maybe we should ask that just before. If someone's going to ask that, right? Someone's probably going to ask that. So, oh, yes, sorry.
We just have a comment from chat, which is so relevant. I don't know if you've met her before, Malara.
Indeed.
She's
Hello, Auntie Malara.
I just wanted to say that justice is a form of healing for us, Aboriginal people, and healing is a form of justice. We don't separate healing from justice.
Beautiful. So I hope everyone heard that, and Auntie, that couldn't have been put more beautifully, that we shouldn't be separating, and you don't separate healing from justice, but none of us should separate healing from justice. And I think maybe that captures in that phrase more of what we've been talking about tonight than I could hope to do, certainly in so few words. Thank you.
Yeah, thank you very much. And I think now we'll open the floor. What we'll do for the rest of the session is I'll get a question from the floor, or the question in person, and we also have people on Zoom that are going to be sending questions in, and I'll go to Eve and she'll read out a question online and we'll discuss that, and we'll go back and forth, maybe once, depending on how we talk. So, opening the floor up to everybody, is there a question that you would like to ask about? Yes, please.
I just want to pick up on the point you were just talking about right at the end there. You sort of talked quite a bit about this dichotomy between working inside the system and working outside the system. And working inside the system to be, I guess, use the phrase like propping up the system, whereas working outside the system, working towards efforts of decolonisation. How strict do you think that dichotomy is, and do you think that the process as a lawyer, I guess, fighting for justice in an individual case, can really be an act of decolonisation itself?
I might just repeat the question for our Zoomers. So the question was regarding, is the distinction between working within the justice system and outside of the justice system really clear?
Yeah.
And the second part was,
is there any prospect for fighting for justice in an individual case inside the system to be an act of decolonisation?
And is there any opportunity to act within the justice system to help someone in an act of decolonisation? Is that right? Thank you.
All right, so the first part of the question, they're great questions, and I don't propose to suggest that I'm going to be able to answer them. But the first part of the question is, I don't think that dichotomy ultimately is useful, and I think it's also a case of this spectrum of ways that you engage or otherwise, and ultimately maybe the question is, how can I most usefully be having an effect? I do think that sometimes you can get captured so much by the system and working within it that you lose the possibility of seeing a bigger picture. And the bigger, like abolitionism, I think is about saying, hey, step back, like see the bigger picture. And so that's where with abolitionism, it points to things like, well, is it a reform or is it a sort of real reform or just a reformist reform? I can never remember which way around that goes in terms of what. But, a question would be, well, it's only really going to be a reform if it decarcerates. If it just sort of makes prison a little bit nicer, but means we'll feel happier about locking people there away, then, you have to wonder. And so I think that sometimes when you're working in the system, you do have to comply by the rules. I'm not suggesting anyone. I mean, I'm a magistrate now. I've taken an affirmation to work according to the rules. That doesn't mean I have to, in my academic world or in my private life, believe that incarceration is the way things should be, or the way that is a solution at all. And yet there's going to be situations where I lock people up. So how's that going to work? That's it, ask me about it in a few years as I proceed along, and I won't speak more about it. But there's contradictions. Basically, we're existing in this world of contradictions. So dichotomy is challenging. But yes, we can be clouded and we can lose sight, or we can just go with the culture that's there. And if that culture is really not seeing the big picture, then we're really maybe not pushing in the right direction. So that's step one. And then a really more challenging, can you work in that space as an act of decolonisation? It's an awesome question. I think decolonising, I don't want to not speak about my thoughts, but I also don't have resolved thoughts about whether it's even possible for a non-Indigenous person to say that they're involved in an act of decolonisation. It's almost, to me, too much of a contradiction, because I think that ultimately we're talking about decolonisation means respecting authority that's been here for millennia. And essentially, where is my authority? My authority really comes from the colonial moment and carries on from there, and a series of rules that have come to this continent as a consequence of that. So for me to assert out of that space that I can do an act of decolonising just doesn't feel right. However, could I get out of the way or create space and enable a decolonising moment? I think maybe, because if in any interaction we have, there's genuinely an attempt to cede the floor and to step from the power and even the language I'm going to use, enable power. Who's enabling power? That's like the white colonial system saying you can have this much power. Well, that's hardly an act of decolonising, is it? But but at least in a personal context, I think it is possible to think about real partnership, and that partnership has to come out of respecting an authority that's in this land and that has been here, and then kind of opening to the possibility that might emerge if you take that seriously. I think that's the best I can do.
Thank you very much. And we might now go to you, Eve. If you could read us, if there's a question.
There isn't. I've been directed by my supervisor, Monica, to read one of the questions that was submitted prior to this.
Wonderful.
Would you mind commenting on the distinction between and tension between the common law and customary laws, the effectiveness and the general perception of certain sentencing courts?
Yeah.
Which is a spicy one.
Yeah. So I don't really feel able to speak a lot about distinctions between, common law and customary law. I think sometimes we use the language English to speak of, we might say customary law, and that's what we speak of. And sometimes that might involve a hidden, that's not real law, that's somehow different. And then, but by the same token, there may be an assertion by a First Nations person, well, we do want to speak about it differently, and this is the way I want to speak about it. And that, of course, is the right. So they might say, well, LORE, which you've heard about, is a much bigger and more fundamental concept than LAW that you learn in law school. Okay, now, I agree completely, even though I barely would be able to touch the surface of my understanding of LORE. But another person might be saying, look, in this context, that's the law, LAW. It may be bigger, but I'm talking about it as law and its equivalent and so forth. I think if I could just come back to that, the sort of question and tie it to the decolonising. I think the point in this country, the unfinished business, is the failure to kind of reconcile or reckon with the authority that is deeper, longer, from time immemorial. It's based in country, which goes back to Auntie Malara's point about justice and healing. And even the NAIDOC thing, of healing country, which really ultimately is about healing everyone on this country too, and ideally moving us towards a situation where all of us don't see ourselves as distinct from country. But I think that the point would be that until we're seeing a plurality, there we go, of legal systems, you know, a different authority base that comes, and one that on, you know, a lot of levels factually is just an assertion of power and an invasion base. And another which really has something that is way deeper and bigger. Until we're in that space, I don't think we can even have that conversation about how do the two laws interact. And then the second part of the question is about circle sentencing. And I can't remember exactly what the question was in relation to circle.
So the effectiveness and general perception, is that?
Yeah, they added a bunch of questions.
Yeah.
In that sentence.
So, you know, I'm working in that space now as a Gallivanti Court magistrate, and shout out to, I won't say my associate, I'll say the Gallivanti Court associate who's here, Sam Cass, an ANU student. So I should say we're working in that space, both as non-Indigenous people. In fact, Lauren, who's at the Aboriginal Legal Service here, who appears before me, also a student, an ANU or ex-student, on a regular basis for countless clients already. So I'm still working the experience out in the circle. But what I can say about it is, for a start, it's still within the colonial criminal justice system. So there is still a sense of colonial capture in that space. And yet, working with the elders is this most incredible experience in which there is genuine authority there that arises from a completely different space. And they have chosen, because they believe in the circle and the impact it can have on those who come before it, to be in that space. Whether they would contextualise that as an act of decolonising, that's really a matter for them. But they're in there because they can see that they can actually make a concrete difference for their people. And I'm in there as a magistrate because I want to work with them in that space and do what we can within that system, within its rules and structures. And that's obviously limited in many ways, but it's also a pretty powerful experience, and in my experience, very different to colonial courtrooms, the standard form courtroom. And perhaps tying back to one of the questions around human beings and story, the circle itself as a kind of construct, if we think about it, at core is something that means that everyone is looking at everyone else in that circle. Now, just in your mind, picture what a courtroom generally looks like, which is lawyers at the bar table, client says nothing, sitting behind them, usually in the chair, sometimes in a dock, and lawyers talking to judge, okay, submitting to judge. Now, take that and think about a circle. And in the circle, if it's a real circle, and we haven't quite got one, but they're building one, if it's a real circle, you can't turn away from the others in that circle. And so even if you're the prosecutor and you've decided this person needs to spend more time in jail, if you're working properly within the circle, you'll say that directly to them and you'll explain why. And that might be hard for you. It's going to be harder for them. They're the ones doing the time. But there's something deeply human and honest about it, and you can't turn away from the humanity and the dignity, or you shouldn't. People still try. But, you know, essentially it's a real privilege to kind of experience perhaps what justice could and should be for everybody, without these hierarchies of benches and this, you know, formulaic patterns where we assert status by where we are in the profession, as opposed to communicating in real terms with the human beings that are affected by the decision.
That's super interesting. And the manner in which space and our arrangement in space can actually affect our relations in these institutions, and the importance perhaps. Changing the architecture, get better architects. A question from the floor. Does anybody else have a question that they wish to speak, that I wish to ask of Anthony? Yes, thank you.
I kind of had this question and you kind of answered it in the very specific circle sentencing context, but I feel like a lot of the time that we engage with it's in a really colonial context, like at law school or whatever it may be. And I was wondering whether, like, you personally act differently or do something differently when you're working with less colonial context.
Can I just repeat that for the Zoomers just once? The question was whether Anthony acts differently in non-colonial In a non-colonial context?
Or like, it's always a colonial context, but you know what I mean.
Acts differently outside the law school and the courts.
No. I think it's more specific than that. I mean, I won't take up whether it's colonial or non-colonial, but let's give it some concrete. If I'm in sitting down with someone on country, let's say away. Now that could be in the ACT with you know, an Aboriginal person or a traditional owner of this country, or it might be in the NT and the community and so on. It's a really good question, and the answer is yeah, I'm actually quite different, and the difference probably I'm quieter. And so, you know, if it's and the sitting down construct, if I'm literally sitting down with somebody, I'm just aware, and I think this would be, I'm just aware that there is so much that I don't know here. And it's not that I'm going to drag a whole lot of questions out and roll, but it's just that sense of there's a time to be silent here. I don't know. And it's often an uncomfortable but a powerful space. And it leads you to reflect on what do we do to other people when we drag them into the colonial space, for example. And so it can be quite powerful, but it's often in the silence and then taking the time, you know, just even if you want to speak and so on, just not. And then you might learn something, and you might not, but you might learn from the silence, or the person might realise, oh, well, this is a genuine communication because this person is not going to assert their usual way or whatever, and then suddenly some things emerge out of us. But yeah, I would typically be, you know, more silent.
Do you ever try and carry that through when you act like with Aboriginal clients?
Sorry,
Yeah,
does Anthony carry that through when he's with Aboriginal clients? Sorry, they're just a...
So I mean, I'll take it back to the NT context where you've got more frequently the language, you know, issues arising, and you've also got protocols about who you can look at and whether you can look in eyes and things like that. And so yeah, and this comes back, I suppose, and this is fitting back to Kelly or Geordie. Essentially, you know, field officer's role was to enable communication so that it could be across difference. And so you would find situations where you needed to sit down next to somebody instead of looking at somebody, but actually literally beside. It might be that you would start a conversation of, you know, that has a different way or a different rhythm to it by perhaps even saying, look, you know, this is what the police are saying in this particular context, but, you know, I'm really just here. I just want to talk, you know, you tell me what the true story is and we can go from there. And that may or may not be relevant in a different context, but subtle differences. And I think they just come with time, but sometimes they come with somebody saying, you can't do that. You just, what are you doing? You know, and then you go, oh, okay. So, you know, some of that, and some of that is about just creating a different space, I think, to some extent. And it's hard to do in different contexts, and we'll get it on. But no, I don't have any kind of formula for it, but I would say, yes, it's quite different. And being open to changing and adapting, perhaps reading the signal that says don't speak now, or don't look, or let the silence be, or see what comes out next and then work off that, or check with an interpreter who's there about what you're doing, or a field officer, or whatever may happen.
Thank you.
Thank you. We might go to Eve again. Are there any questions?
Yeah, we have one from Michael. It's about institutional racism. Just been reading the question because it's a little bit long and obviously full of frustration because he's a practicing solicitor. He said, when we act for First Nations clients, we come up again and again with history repeating itself on say instance. The problem is that innocent First Nations people spend years and years long in prison, and many are never provided restitution after the exoneration. The real issue seems to be that no matter how much of your time you spend at the whole facing migrants in cases, the pressure takes
Sorry, could you just repeat that last bit? I think some of us may have missed it with the door.
Yeah, we'll keep going now.
Basically, once people have spent a lot of time in prison, despite the fact that they've been in prison, a lack of restitution, And he asks how people who are early in their law degree can be involved in law reform, and do you have any advice for that?
Okay. Yeah. So I think that one thing, even if you are working in the system, in the machine itself, so to speak, is to be outside it as well, and to realise that there is a struggle, there is powerful resistance, there's incredible strength, First Nations strength, that you will see at Black Lives Matter marches, that you will see with the ongoing tragedy and travesty that is deaths in custody, and that being restricted to only being involved within the colonial criminal justice system itself in an operational way can just lead to an incredible sense of frustration and an inability to step outside and realise, well, there may be policy wins, there may be changes, we may be in a moment we don't know where we can really take a different direction. And I think that's where, I mean, the only encouragement I have for young law students is to think, well, there's not just one path here. If I see the justice issue, there may be all sorts of different angles that come out of it. There may be an angle where I see the flaw or create a forum where somebody is able to speak. It may be that I just turn up, and engage and assist, protest organisation. There could be any number of ways. It may be that I'm silent here because there's a First Nations voice who wants to speak, or I might be able to amplify that voice. So, yeah, I think if you're just stuck within that system working, then the frustration, and you're alive to the reality of it, the injustices build up, and it's very, very easy to just simply kind of burn out. Whereas I think you can actually use the two experiences to intersect with one another. So you learn stories in real terms on the ground in these courtrooms, working with people, that enables you potentially to have an impact in a different setting. So I don't know if that's, but I think there is something pretty powerful about knowing that there are multiple ways that you might have a positive impact on the direction of the country that might one day lead to decarceration, as opposed to this continuing trajectory of hyper-incarceration for our First Nations people. And I shouldn't say our, because I think that's a colonial way of speaking for First Nations people on this continent.
I think that's a really interesting point, being constantly aware of the language that we use and the way it can manifest in the world. Thank you. And we may have time just for one more, hopefully for two. But, sorry, I did see this question first, and since it's arbitrary, I'm just going to have to go with that. But we'll hopefully get to your question. We'll see how we go. So if you would.
I just wanted to touch on your point about taking Indigenous law seriously as law. Obviously, colonial law has had very much a devastating impact on First Nations communities. Do you see the possibility in the future, I guess, of Indigenous law influencing colonial law in a kind of third way?
Sorry, just will repeat once again, sorry. It's a question about the potential influence of customary law, or law, L-O-R-E, on, I guess, the common law or institutional law in Australia, the potential for maybe law reform or influencing that law.
Yeah, I mean, I'm not sure if quite that captured the question, but I think, but thank you for the Yeah, I would absolutely hope so, but I think I would want to take it bigger, and that is if we don't get serious about the reality of Indigenous law and worldview on this continent, if we don't see the bigger picture, which might take us to questions about connection with country, with others and so forth, we're kind of stuffed as a planet, frankly. Like, if we don't really come to terms with Indigenous wisdom and see that the system that we work in, the individualised ways that we work, are just causing harm and incalculable harm in so many different ways, then we're really, really in trouble. So in a sense, it's the other way around. If we think of perhaps not, it's not, that we might hope for, First Nations laws to influence and change for the better the colonial law. At some point, it's going to have to get more radical than that. And we're going to have to think that we turn the lens back on the colonial law itself and start maybe this is super idealistic and kind of ridiculous, but ultimately, if we're going to have save the planet with climate change, we have to go back to putting everything back on the table and saying, well, it's not so much about can we have some small influence here, but can we really find a way to engage seriously with what an Indigenous worldview, what Indigenous law, what Indigenous ways of being are, and see that as an opportunity for everyone who is on this continent to live a life that really could be so much more than the life that we're living. So we are harming, like the colonial context is not just harming, those that were the colonised, the traditional owners of this country, First Nations people. It's deeply harming all those who are settled on this country as well, all those who were colonisers or settlers. And so, yeah, there's the potential, and I do hope for that, and I do see that. And I see the potential working its way out for a human interaction that arises in through you. So that's really where we're all placed in this, I think. And you may or may not see it. It may not come to you until some later point, or it may not kind of ever feel like it's there. But the potential, I think, is there because you have this capacity to engage and to really open up to stories, to open up to different ways of being, and potentially to break the grip of, thinking the thoughts of the colonial culture, such that thoughts of First Nations culture start to really alter the way that you fundamentally think.
Thank you so much. And can I just get a confirmation? It is 7:30. That clock's right.
7:25.
It's 7:25. Oh, wonderful. Sorry, I've been looking at that one. That's wrong. But we were doing. I know we've got your question, but since we do have to give respect to the Zoomers, there's no Zoom questions. Over to you, please.
Thank you. So my question sort of follows the question that was just asked about, do you think we can ever truly achieve justice for First Nations people and decolonise the system and Australia after colonisation, if there's ever hope of doing that? And sort of if you have a faced emotional burnout in working in this space with this knowledge of the trauma that has been produced from First Nations people and the difficulties in decolonising or trying to achieve this Aboriginal justice.
Yeah. So I think whether justice can be achieved is not something as a non-Indigenous, from an Indigenous perspective, is something that I can speak of from a non-Indigenous as a non-Indigenous person. I think whether it's achieved in some, future time or not, maybe that's an open question. I think it's much more of a process though, and I think there's a question of engaging in that process. But even in each step of the way, for me to sort of assert, well, now that's some justice, that's pushing in the right direction is a difficult thing. But I suppose I wouldn't be here and I wouldn't be committed to that. I wouldn't be part of the family that I'm part of without this being understood as really an organic process, and ultimately one that, and this ties to your well-being question, can hold me up as a person within this system and keep things going. Because if I feel like at least my intention and the work I'm doing has that potential, then in fact that's a situation where I can emotionally thrive. Where does it really go wrong? I'll tell you, in my experience, I'll just speak to my experience, it's when we've forced ourselves into a box and we think that this is what we should do and that this is the right thing, this is what we as lawyers or law students, we have to do this thing because that's really what all the narratives are telling us. And yet something inside our heart goes, I'm crushing myself in this process of trying to be something that I'm not. And I haven't had that experience, even though it's been often depressing and challenging, when at least I feel like I'm part of a process which is going in the right direction. How could I possibly know it's going in the right direction? I could only know that to the extent that I'm working with First Nations people, because they're the ones who will determine really if it's the right direction. And when I talk about direction, it's going to be all over the place, but in general terms. So I do think, and maybe this comes to the LRSJ and why I think law reform and social justice as a movement for law students is so important. I actually think that the well-being conversation and the values conversation and the doing positive work, those two are integrally linked and you can't really remove them. If you, having come to law school, find yourself in a situation working in the law where you really just feel like you're not doing good things for people, if you've been forced to, it's not your fault, but you've been forced to turn your back on your original motivation and what your heart speaks of to you about who you should be as a lawyer. And that is a situation where we're not just talking burnout, we're talking, you know, not too many steps to really turning your back on yourself. So
That's a wonderful comment, and I think that might, because that brings us back to the comment made by I forget the name. Sorry, Auntie Malara. Wonderful, and I think that might be a wonderful way to, us to finish up. If we could get that, if Eve, you would repeat that comment to us. I think that is a nice, because that seemed to be, you mentioned that it really encapsulated, and if we get that comment and we can, you know, repetition is learning for some of us. So I think it would be good for us to hear that again and wrap up.
She also didn't want to call customary law, she wanted to call it first law. But she said justice is a form of healing for us, and healing is a form of justice. We don't separate healing from justice.
And so, thank you very much. Now we definitely are on 7:30, am I right? Exactly on 7:30. Well, I would like to thank all of you for coming. I would very much like to thank you, Anthony Hopkins, for coming and speaking to us about this important issue. And we do have, I had a gift for you, but I forgot it. So I can only give you an IOU. And the gift was, which I encourage you all to go out and buy, to Evelyn Orland's new book of poetry, Drop There, which is, she's a magnificent poet, now based in Melbourne, a young Indigenous poet, but a poet. And she is wonderful, and I really encourage you to you'll read it because I'll give it to you.
you will.
And it's still on Book Depository.
Yeah. And thanks so much for coming. Really appreciate it. And good luck for all of you with law. And I'm sure, no doubt, I'll see many of you, even some of you tomorrow.
And thank you, Zoomers, for zooming in, and extend our acknowledgements of your lockdown situation. If you are indeed in lockdown, we solidarity with you in lockdown.